Jane, and I just wanted to start by thanking you and Nuala and the Green Foundation for inviting me to speak this morning. It's a real pleasure to speak and to see so many familiar faces and old friends. So I've been asked to speak at this event really to look at as Joan has said, at the merits of having an amendment to the Constitution to include protection for the environment, but to give a sort of introductory talk at this panel, given that the other speakers will address different aspects of that, and to speak a little bit about the Constitution itself. And I'm conscious that many of you know a great deal about the Constitution already, but I thought what I would do is I'd speak a little bit about the Constitution, but also about the Constitutional Convention, with which I've been very involved, and which and at which the issue of environmental protection was certainly mooted. So I wanted to speak briefly first about Bunreacht na hÉireann, the Irish Constitution, with which you'll all be familiar, enacted by the people on 1st July 1937, in operation in this state from 29th December 1937, and widely and sort of somewhat apocryphally seen as a creation of Den Taoiseach de Valera, with a good deal of help from his friend Catholic Archbishop McQuaid. Although there is a sort of a newer, if you like, view that in fact senior civil servant John Hearn had a much more central role in the drafting of the text than had previously been acknowledged. And many of you will be aware of the really wonderful comprehensive text by now High Court Judge Gerard Hogan about the drafting of the Constitution and the history of that, the history of the development of the text. So the Constitution has a preamble and 50 articles, most of which deal with governance of the state. Joan mentioned the separation of powers doctrine, so the Constitution deals with the three tripartite divisions: the judiciary, the government and the legislature, or Oireachtas. It deals with, in Article 4, the name of the state, although interestingly, as many are aware, the state is referred to simply by the name of Ireland. The name of the state is Éire, or in the English language, Ireland, and the state is not referred to as a republic, because of course the status of the republic came later in 1948. So when the Constitution was enacted, Ireland still didn't have the status of a republic, and it's one of those issues that at some point will have to be revisited in a review of the Constitution, is what we say in the Constitution about the name of the state, and is it an accurate reflection of the name of the state. Article 8, given we're in Seachtain na Gaeilge, speaks about the first language, of course, which is Irish, and so on. So you have a whole range of different articles dealing with governance issues, setting out fundamental principles of governance. Articles 40 to 44 of the Constitution deal, however, with a different group of provisions: fundamental rights, essentially a Bill of Rights enforceable by individuals, and including such rights as the right to freedom of association, the right to freedom of expression, and so on. Although, in fact, both of those rights, as many will be aware, are very heavily restricted in the language used in the documents, in the constitutional document. The Article 45 of the Constitution deals with directive principles of social policy, regarded as sort of guidelines to the legislature and not directly enforceable by individuals before the courts. And I'll return to those because we recently debated this aspect of the Constitution in the Convention. So the Constitution can only be amended by referendum of the people, and in this way it has been amended 28 times, most recently last October to provide for a Court of Appeal, although, as we know, the other amendment put the same day to abolish the Seanad was happily not passed, and I was happy to campaign against the government on that particular issue. The Constitution is now more than 75 years old, therefore. While its provisions have been subject to much criticism, in general the governance provisions have lasted relatively well. As I've said, there are some aspects that require amendment, that do clearly require amendment and updating, but really the most focus of critique has tended to be on the Bill of Rights provisions, the fundamental rights provisions in Articles 40 to 44. And it's important to recognise the family of rights protected in those articles, which are essentially civil and political rights, or first generation rights. That is, rights that are really formulated as freedoms or liberties upon which the state should not encroach. So, as I've said, freedom of expression, for example, the fact that people should not be prevented or unduly restricted in expressing their views and opinions. The right to freedom of association, similarly. The dwelling of the citizen, and a very important provision that's actually given rise to a great deal of case law. The dwelling of the citizen is inviolable and shall not be forcibly entered in Article 40. So these are, essentially prohibitions or restrictions on state interference with people's liberties. And that's the notion of civil and political rights. rights. What is lacking mostly from Articles 40 to 44 is the second generation set of rights, or family of rights, the social, economic and cultural rights, economic, social and cultural rights that we see guaranteed in constitution, in more modern constitutions. Now, there is an exception to that in Article 42, which guarantees the right to education. These are generally understood as rights that impose an obligation on the state. So the state must, under Article 42, provide certain levels of education, although, as we know in the Sinnott case, that was the extent of that right was somewhat limited. The extent of the right was somewhat limited. But the right to education is nonetheless an important social and economic right that individuals can enforce against the state. What we don't see either is what we call third generation rights or group rights, community rights, such as the right of the community to a sustainable environment, for example. So again, I'll come back to that. Article 45, which, as I've said, is not directly justiciable, is an article that deals with a much more social economic type of right. So Article 45, dealing with directive principles of social policy, requires that the state shall strive to promote the welfare of the whole people, must ensure that the ownership and control of material resources of the community may be so distributed as best to subserve the common good. So there's much more communitarian values expressed in Article 45, but that's not directly justiciable or directly enforceable by individuals before the court. So, many of us, including myself, have been very critical in our own writings of the limited conception of rights in Articles 40 to 44, and we've argued for a broader formulation to incorporate, for example, rights such as the right to housing, which imposes a positive obligation on the state to ensure citizens have adequate shelter and to have a home. We've also been critical of the very elevated status of the right to property, the right to private property in the Constitution, which is given a great deal of primacy in the Constitution, and which has been used in a number of cases to curb the right to equality, for example. And I'm thinking in particular of the decision of the Supreme Court on the first formulation of the Employment Equality Bill in the late 1990s, when the court said that an obligation on employers to make reasonable accommodation for people with disabilities was unduly encroaching on the employer's property rights. So property trumped equality in that case, and in a number of other cases we've seen property rights again used against what we might understand as rights to equality or more communitarian rights. I've also been very critical, as have others, of the theocratic ideology apparent in much of the language of the fundamental rights articles, particularly Article 41 on the family. And many of you will be well aware that, extraordinary in 2014, Article 41(2)(1) still speaks of woman's life within the home and of the role of mothers in the home. There's no mention of fathers. It's most unfair, except, of course, in the preamble, which refers to Jesus Christ having sustained our fathers through centuries of struggle. So apart from the religious reference in the preamble, we don't have any recognition of the very important role, paternal role. So in this context, I've perhaps very briefly and somewhat superficially given you some sense of some of the issues around the language of the fundamental rights articles in particular. And in this context, and because of sort of growing criticism about the outdated nature of these provisions, the idea of a review of the Constitution had been mooted for some time. And in fact, there had been some expert groups, a major expert group, comprehensive review of the Constitution in 1996, and the Joint Oireachtas Committee on the Constitution, which over a series of different reports has in recent years been reviewing aspects of the Constitution. But in fact, a more substantive review of the Constitution was proposed by the Labour leader in April 2010, by Eamon Gilmore, at a Labour conference in Galway. He called for the establishment of a convention to revise the text of Bunreacht na hÉireann in advance of the 1916 centenary. And that, gave an impetus then to, and I must say that, I think in the 2011 general election, all political parties called for some form of political and constitutional reform. So, given that context, given the centenary that was approaching and so on, the programme for government drawn up in 2011 following the general election included, therefore, a proposal for a constitutional convention. In July 2012, motions were passed in both Dáil and Shannon to enable the establishment of the convention, and it held its first meeting in December 2012. And as many of you will be aware, it has just recently recently, in recent weeks, concluded its business. I was the leader of the Labour delegation to the convention and was a member of the steering committee of the convention. So I've had a very active involvement in the work over its lifetime. And I wanted to address really what the convention did and speak then about the right to environmental protection in that context. And it's actually very nice, very good timing to be able to look back just a couple of weeks after we've concluded our work and review what the convention did. Briefly, the remit of the convention was to consider and make recommendations to the Oireachtas on a range of specific matters within a designated time frame. Within 2 months of the first public hearing, we had to make recommendations on 2 preliminary matters: reduction of the presidential term of office and reduction of the voting age from 18. And within 10 further months, we had to provide a report and recommendations on 6 further matters, including review of the Dáil electoral system, giving citizens resident outside the jurisdiction the right to vote in presidential elections, and provision for marriage equality, for marriage for same-sex couples. And we also happily were looking at the amending the clause on the role of women in the home and removing the offence of blasphemy from the Constitution. But we also had a sort of an open-ended clause that we could report on such other relevant constitutional amendments as we might recommend. And the government in turn then had to commit to providing a response to each recommendation within 4 months and stating whether or not they would accept our recommendation for a referendum, if indeed we recommended one. Now, there was a lot of cynicism, I have to say, when the convention was initially established in 2012, that its remit was too limited. These were very specific, very defined issues, and that and a scepticism about whether it would have any actual outcome. I think the work of the convention has confounded those critics over the 14 months or so that we worked, because we carried out the work meticulously and carefully. There was enormous commitment shown by citizen and politician delegates alike, and by a really superb but very small administrative staff. I think what we're seeing is some transformative potential from this model. And I should say what was really notable was that this was a citizen-led model. The convention was made up of 100 members, 66 of whom were citizens. That is, people chosen randomly but according to demographic profile of the population. So a polling company, in fact, carried out the selection process for the 66 citizen members. And in other words, I remember seeing the list. It was very interesting. There had to be 3 people under 25 from the west of Ireland, 2 women and 1 man, for example. So they had to ensure that there was a match to the age, gender, class and geographic profile of the population. And the 66 members, therefore, were supposed to be directly representative. There were then 33 politicians selected proportionate to Oireachtas representation, and 1 chairperson, Tom Arnold, former and I think everybody knows of Tom's great work with Concern. We had our sessions were held in the Grand Hotel in Malahide, but we also had a series of regional meetings last October, to which many people attended who hadn't previously engaged directly with the convention. We recommended that we made a series of recommendations, a number of which have already been accepted. So, for example, we know that there will be a referendum next year, I think next year, on reduction of the voting age, that the voting age should be reduced to 16, and that the age of candidacy for presidential candidates should be reduced. It's currently 35. You have to be 35 to run for president. We suggested or recommended that be reduced, but we actually voted against any change to the presidential term of office of 7 years. And the government is committed to holding a referendum on those. Perhaps the most high-profile recommendation of the convention, which again has been accepted by government, was that we made following our session in April of last year, where we were looking at marriage equality, and we had a very significant majority, 79% favoured changing the constitution to allow gay couples to enter civil marriage. And the announcement of this result it created a good deal of media attention, and the government committed to holding a referendum on this subject next year. That I think gives you a flavour of the work of the convention. And some of the recommendations still have to be responded to by government. So we're still waiting to hear. But there may be a series of referendums, therefore, held next year on what some people have suggested should be called Constitution Day, a series of referendums to amend different aspects of the Constitution in line with our recommendations. But I want to turn really to the open-ended clause, the 2 other relevant any other relevant constitutional amendments. We were given extensions of 2 further weekend sessions to debate issues, and given the work we had done, in the experience we'd had was that really only 2 issues could be debated, 2 substantive issues over 2 weekend sessions, and there was therefore a good deal of debate in October, November of last year as to what we should choose as our 2 extra issues. And we had the regional meetings at which quite a number number of individuals and groups argued that inclusion of a clause on environmental protection in the Constitution should be one of those issues to be debated. And there were a good number of submissions made to the Convention which argued for that to be one of the two issues we deliberated on. We made a submission, I made a submission for the Labour group, arguing that this should be one of the issues we included, along with the inclusion of economic, social and cultural rights. The outcome, unfortunately, was that environmental protection was not included as an issue for the last two sessions, despite the strong arguments made at the regional meetings and despite a strong argument for its inclusion being made by the Convention legal advisor Leo Hegarty in November 2013. And you'll see a video of that presentation on the Convention website, constitution.ie, at which she summarises the effect of the submissions that were made on this issue. So, you know, it was unfortunate, but there were so many issues that people were arguing about inclusion, and certainly economic, social and cultural rights was one that had huge and widespread support. And that was one of the issues we discussed. In fact, it was the last issue we debated in the last weekend in February. And I'm glad to say there was a strong majority at the Convention in favour of the inclusion of justiciable economic, social and cultural rights in the Constitution. There's a report currently being prepared by the Convention team, which will be up on the website very shortly. The topic of Dáil reform in the end won out as the other topic for discussion by the Convention, and we debated that over the weekend of 1st to 2nd February. I felt myself, I mean, just a sort of private view that I'm sharing with all of you, that perhaps, you know, it was too big a topic, and a lot of the issues we discussed didn't actually require constitutional change. And I think in retrospect, something more succinct and more directly relevant to the Constitution would have been preferable to select. But, you know, that was the vote of the delegates. And the issues really that were highlighted were the need to strengthen the role of the Oireachtas committees and of the Ceann Comhairle, to strengthen the independence of the Ceann Comhairle in the, and if necessary, make constitutional change to that effect. So that's what we've recommended. What about the right to protection of the environment? Well, I think there's a very strong argument that any future constitutional convention should take the issue of environmental protection as one of the first issues for consideration. And, you know, I say that, I suppose, you know, again, looking back at the work of the convention, that you know, the strength of this convention was that it was taken seriously by citizens and politicians alike, that its recommendations have already, some of them have already been accepted by government. I think we can expect to see more accepted, and we can also expect and anticipate a series of referendums next year, either on the same day or over a number of days, dealing with some of the issues we've debated. I think there is a strength to dealing just with specific issues. We did have other reviews of the Constitution that were much more comprehensive, but that have gathered dust ever since. You know, in a way, to be taken seriously, to give rise to actual change, you need to be dealing with specific issues, and you need to have a tight time frame. I think those are some of the lessons from the convention. I very much hope that, I must say again personally, that the two issues that will be first on the list for the next constitutional convention, and I know one of our strong recommendations was there should be another one, the two issues on the list should be environmental protection and dealing with the theocratic influences, in particular the removal of the need for religious oaths. We did recommend removal of the offence of blasphemy from the Constitution already. Religious oaths is something we didn't get to see, and again there were very powerful arguments that should be something a convention should consider. I think I'll finish perhaps just by saying, you know, that in my mind, what is the strongest argument for inclusion of a clause on environmental protection into the Constitution? Well, I think it would send out a very important message about our commitment to ensuring that you know, the unique natural environment of Ireland should be preserved for future generations. It would give a strong message internationally about the value we as a society place upon protection of the environment, and it would also, I think, be in keeping with modern movements in constitutional reform. And I'm thinking in particular of the relatively new South African Constitution, Section 2 of 2.24 of which provides that everyone has the right to an environment that is not harmful to their health or well-being, and everyone has the right to have the environment protected for the benefit of present and future generations. I think it's wonderful language. I think it expresses really admirably the sort of values that we as a community should be expressing in our Constitution, and I think it would move our Constitution forward to a recognition of third generation or group or community rights. So I'll certainly be arguing strongly that we should be including that in any future convention. I know Roderick is going to deal with some other constitutions that have similar provisions, and I think we could argue that, you know, there is a powerful movement now about inclusion of this sort of right in modern constitutions, and I think civil society has a hugely important role to play in persuading this or future governments that this should be an issue of priority for constitutional reform. Thank you.